The three-judge bench of the Karnataka High Court, headed by the Chief Justice, has given its order on the hijab controversy. That is the big headline of the day and the big top of the mind issue. So we've done a speed reading of the judgment. It's 129 pages. It's not such a difficult read. It's actually a well argued, cleanly written judgment without too much verbiage that you worry about when you see our judges, particularly multiple judge benches, giving their orders on constitutional issues. Now you can agree with it or disagree with it. What I'm saying is it's an easy read. So we will talk about that, and if we are left with time, we'll talk about two more things in the passing. One about a great leader whose anniversary falls today, that is Kanshi Ram, the founder of Bahujan Samaj Party, and I will do a little bit of storytelling. I will tell you about my first exposure to him in 1988 when he contested his first election in Allahabad against VP Singh and Sunil Shastri, that historic by-election, and that's where he announced his arrival on the national political stage. And I will also share a couple of interesting pictures about that. And also we'll talk about a book by somebody who I regard as my mentor, as one of my most important friends, and an older sibling that my parents never gave me, that's Arun Shourie. So he's come up with this sort of the memoir of his life as an editor, and that's an essential reading. I will just introduce the book to you. I'll be reading it later at night. So back to the hijab issue. Now the High Court has given a 129-page order. The three judges who've written this order unanimously are the Chief Justice, Mr. Krishna S. Dixit, second judge is Ritu Awasthi, and the third is Mrs. Jabunisa Mohyuddin Khazi. So these three have given a very clear order. Now what is the order? They've said that petitioners had come up to them, various petitioners, and they had raised 4 questions. So this judgment has actually done a cut the clutter kind of job in the judgment itself. They've said here are the 4 questions that we are dealing with, and they've highlighted those 4 questions like this to make it more comprehensible. Number 1, whether the wearing of hijab is an essential religious practice for the Muslims and should have protection under Article 25 of the Constitution, which gives every Indian citizen the right to practice their religion as they are expected to. Number 2, was the prescription of school uniform a legal or constitutional right of the committees that did that or the schools that did that? Because schools basically said that we are prescribing a uniform, everybody wears the same uniform. You cannot say that because I'm a Muslim, I have the right to wear a hijab. Third, whether the government order that Karnataka government issued at the peak of this controversy, putting a restriction on any religious attire in schools, whether that order is constitutional or that is violative of Article 14 or 15. Article 14, as you know, is that everybody will be ensured equality before law, irrespective of religion, ethnicity, language, gender, etc., etc. And 15, that the state shall not discriminate against anybody based on the same considerations of identity. And number 4, whether there should be a disciplinary inquiry ordered against some respondents, and these were basically teachers and people heading these schools and colleges, that they used this arbitrary power and harassed school children, school girls or college girls. Now, first of all, we have said this before, but I will also explain it again, that in Karnataka, the term college in this context can be misleading, because in Karnataka, after class 10, for class 11 and 12, that's for plus 2, you go to these junior colleges. They are called colleges, but they are actually schools. They are for the plus 2 system, a bit like inter-colleges in the Hindi heartland. It is after you pass your class 12 here that you go to a proper college. So these are schools which are like junior colleges, whatever their name, and so therefore they prescribe uniforms. Colleges, degree colleges do not have uniforms, and there you can wear what you want. So if these 4 are the questions, what are the answers that the judges have given? So answers are very simple, and the judges are, as I told you, Justice Krishna Dixit, Justice Ritu Awasthi, Justice Jabunisa Mohyuddin Khazi. So the answers are very simple. One, that they say that they have found nothing in the reading of the Quran and the commentaries on the Quran that says that wearing of hijab is an essential practice, right? And there is some detail on that which I will come to, because they've also leaned on some well-known Supreme Court orders on this. Number two, they say that the prescription of school uniform is a legal and constitutional right, that the schools have not violated anything. Schools or junior colleges have not violated anybody's right, nor have they misused any powers by doing so. Number three, they also held that the government order laying down that no religious attire will be worn in these schools or junior colleges, that order was correct or valid. And fourth, they have said that there is no disciplinary inquiry required against these teachers or principals or college managements, because they were, after all, only following valid rules and valid orders. Now, the judges have actually gone back to quite a few of the well-known judgments in India's legal history. One of those is Indira Gandhi versus Raj Narayan. Raj Narayan, if I may remind you, Raj Narayan was a maverick leader of the opposition. He defeated Mrs. Gandhi in Raebareli in that post-emergency election in 1977, and in the Janata Party government that came up subsequently, he became the health minister. In this case, the Supreme Court defined Indian secularism. And the Supreme Court said, look, in India, secularism means, in India, religion defines many aspects of our life. And this was actually reflecting what Ambedkar had said during the Constitutional Assembly debates. Ambedkar had said that we have so many religions. Our religions tend to define and also sort of prescribe on all aspects of our lives. We cannot make all of these rights protected under the Constitution. So what the Constitution or Article 25 will protect is essential practices of a religion. So whenever a question like this comes up, a court has to determine whether this is an essential practice or not. Now, this is also something that came up in this Sabrimala case in the Supreme Court. And there, that judgment written by Justice Chandrachud had said that, look, you might say it's your essential practice, but it also has to pass the test of constitutional morality. So that is the new thing that was added. But these judges, also quoting earlier Supreme Court orders, Karnataka judges, they tell us that, after all, just as Article 25 gives anybody the right to follow their essential religious practices, other articles also say that dignity of human beings, dignity of citizens are also paramount and also guarded under the Constitution. So any practice of a religion can't be called essential if it is violative of the dignity of anybody on the basis of gender, for example. That is something that has now been redefined more succinctly as constitutional morality in the Sabrimala cases. So in that Indira Gandhi versus Raj Narayan case, the Supreme Court actually defined Indian secularism quite clearly. And Karnataka judges say that this definition was made even before the word secularism was inserted through Constitutional Amendment 42 during the emergency. They say that was added later, but even before that, our Constitution was fundamentally secular. And they quote this judgment from Supreme Court to say that, look, secularism in India means that the state shall have no religion. It doesn't mean people will not follow their religions. State shall have no religion. There will be no official religion. India is not a theocratic country. So Indian definition of secularism, this Supreme Court order said, is to prioritize secularism in its own decisions. It is not the antithesis of religious devoutness. That means people can be religiously devout, and people who are in the government can also be religiously devout. But the state itself shall follow no religion or privilege any religion. And the Karnataka High Court judges also refer to a section 51A. This is the part of the Constitution that lists citizens' duties. And they say one of the duties under Article 51AE is to promote harmony and brotherhood among all religions and to avoid anything derogatory to women as well. So they've also used this to develop their doctrine on why they think hijab is not an essential religious practice. So the judges then go on to quote also experts from elsewhere, the practices from America, from Europe, right? They delve into those debates. I see the names of Bertrand Russell, Will Durant, all pop up in the judgment, and then they say that a religion cannot have an essential practice protected by the Constitution that militates against the constitutional protection of dignity and individual freedom provided by the Constitution. And that's where the question of dignity of women and equality of gender comes in. Judges say that unlike in America and Australia, where there is total religious freedom, Article 25 in India places limitations. And then they say, and I'm putting it very briefly, that Article 25 not only protects essential religious practices, but also its engagement with the constitutional values. And that's where the question of constitutional morality comes in. For utmost clarity, there is no ban on wearing of the hijab. I see many headlines on my TV screen saying hijab ban upheld. So it's not as if wearing of hijab has been banned. A person can wear the hijab as she wishes in normal life and work. It's only where a uniform is prescribed, you cannot claim that you have a fundamental right to wear the hijab because it's an essential religious practice. That's all. Where a uniform is prescribed. In normal life, out of uniform life, there is no ban on the wearing of the hijab. Now, they go on to quote many Islamic commentaries. They rely on a particular scholar, Abdullah Yusuf Ali, and his commentaries on the Quran. And they quote saying that the Quran says, and this is verse 256, let there be no compulsion in religion. Also, quote, compulsion is incompatible with religion because religion depends upon faith and will, and these would be meaningless if induced by force. So they are quoting the scripture. Then again they quote from the Quran, privacy should be respected and utmost decorum should be observed in dress and in manners. The Quran also underlines the need for modesty. But does all of this or any of this amount to hijab being an essential religious practice? The judges say no. So the judges quote also from an earlier Supreme Court order that says, look, just because you don't wear hijab, it doesn't mean you become sinners or Islam loses its glory or ceases to be a religion. It is not an essential practice. That is the conclusion they arrive at. So this is the nub of the judgment. One, that Islamic scriptures and the Quran itself shows that this is not an essential practice. There is no compulsion. Number two, that even if you want to call it an essential practice under Article 25, you cannot get protection for that if it militates against other principles, other freedoms or other rights under the Constitution, and it also must pass the test of constitutional morality. Now I know that many people ask that how come then Sikhs are allowed to wear their turbans or their attire in spite of the uniforms, including in spite of the uniform laws, even in the armed forces. So the Constitution, Article 25, specifically already makes an exception for the Sikhs, saying that they have certain essential religious practices. So I will, just for your convenience, just use that little part from Article 25 and put it on the screen. Please check it out. So there is no exception made in that case by the courts of law or by the way the law is implemented. That is already provided for in the Constitution. Now, what interests me is something that comes towards the end of the order. They say that they are disappointed that this wearing of hijab in the schools even became an issue. They say that uniforms that the college development committees have prescribed are a reasonable restriction, right, as provided for under the Constitution. And they say this dress code has been there since 2004 and there was never a problem. So how come this problem came up all of a sudden? And this I find a little bit uncharacteristic of a court order, of a high court, 3-judge high court order. But I will just read this passage from it, which comes towards the end of the judgment. So I quote, "We are dismayed as to how all of a sudden, and that too in the middle of the academic year, the issue of hijab is generated and blown out of proportion by the powers that be." This is after they've said that since 2004 there was no problem. The way the hijab imbroglio unfolded gives scope for the argument that some unseen hands, and they put this in single quotes, that some unseen hands are at work to engineer social unrest and disharmony. And then they go on to say that speedy and effective investigation into the matter is important. They say they will not say more because this is being investigated. So a speedy investigation is important and the culprits must be brought to book, brooking no delay. That I think is the strongest part of the judgment, and it will be controversial, and you can be sure that this will be now challenged in the Supreme Court, and let's see what happens. But I'm just interpreting for you the constitutional principles the judges have used to arrive at these four conclusions. Now, Kanshi Ram. Kanshi Ram founded the BSP, Bahujan Samaj Party. I saw him first in the summer of 1988. Summer of 1988, Indian politics was at a turning point. That is when VP Singh had left Rajiv Gandhi's cabinet on the Bofors issue, saying that Rajiv Gandhi was not investigating the Bofors issue fairly, nor coming clean on it. So he went out as like an anti-corruption crusader much before Arvind Kejriwal. And because he resigned from the government and the party, he also resigned from Lok Sabha, because of which he decided to fight a by-election. This by-election was held in Allahabad because Amitabh Bachchan, who had been elected on the Congress ticket earlier, he had resigned from that seat, so that seat was vacant. So VP Singh contested from there. Against VP Singh, Congress put Sunil Shastri, one of the sons of Lal Bahadur Shastri, late Lal Bahadur Shastri. And this was Allahabad, their hometown also. So this was quite an election. Suddenly in this, a third force came in. And the third force was Kanshi Ram, who almost nobody knew at that point in political journalism. He was known as an activist, etc. He had held some rallies with some other opposition leaders, sometimes with some separatist leaders also. He had already come up with the concept of the Bahujan, that people who control power in India are a small minority, that is upper caste Hindus, whereas all the rest, that is minorities, Muslims, Christians, Sikhs, tribals, Dalits, other backward castes, they are in a very vast majority. So they are Bahujan, but this was still sort of academic, etc. This was not finding political traction. So Kanshi Ram, whose anniversary falls today, he decided to contest in this election to make national headlines. Not very different from Arvind Kejriwal going to Varanasi in 2014 and contested against Narendra Modi. He knew he was going to lose, but this was guaranteed to get him national headlines. That's what Kanshi Ram also did, and that's what established him as a political figure in India. Now, I covered that election for India Today magazine. It was a cover story, and you know what? That election also gave me my first TV story. It was the first time I was on camera on a TV channel. I was also live. It was a Doordarshan setup. The queue broke down, so there was nobody to queue me, telling me when to start speaking. This was the election special show that Pranay Roy used to do for Doordarshan those days. So I had to look. They placed a black and white TV in front of me, and they said, when your face comes on the TV, that means the camera is on, you start speaking. So there was a tube light effect. If you hear that video, that I wait that 1 second, I watch my face like this, and then I start speaking. I will share with you, if only for your amusement, a picture from that telecast. Please see that. Now, what is the kind of campaign that BSP ran or that Kanshi Ram ran? That was very interesting. Until recently then, Kanshi Ram had been hobnobbing with people who could be called separatists or people who were not really into mainstream politics. But now he was becoming a patriot. He was now reminding people that he comes from a traditional military family in Punjab, from village Khawaspur in what used to be Ropar district is now Rupnagar. And he reminded them that 8 members of his family, that is 8 ancestors, had fought in World War I, 2 had fought in World War II, and also that 2 of his cousins were para-commandos in the Indian Army, and they had died fighting in the Golden Temple during Operation Blue Star. So he had burnished those credentials of his as well. And then in his entire campaign, there was a military sense of organization. So there was a Hotel Tausi in Allahabad where he had taken an entire floor, 6 rooms. That was called Control Room. From Control Room, they reached out to contact centers. It was just like the army, in fact, special forces. Then he had a motor vehicle fleet. He had supply dumps and also langars in various localities, just like the armed forces. And again, like the special forces, he had 7 squads of workers. And what were these squads? There was a painting squad whose job it was to paint 500 giant blue elephants across the city. So there was a painting squad, a printing squad for posters, etc., a bicycle squad, a begging squad. Now, what's a begging squad? He said, my begging squad will go to Dalits and the poorest people and say, give me a 2 rupee donation. And he said, 2 rupees don't matter to me. But you know what happens? When a really poor person, when a sweeper, his words, when a sweeper gives me 2 rupees, what will he do to the Congress people who come to buy his vote? He will throw chappals at them because he's already invested in me with his hard-earned 2 rupees. So he had a begging squad, an awakening squad, a speaker squad, and an intelligence squad. So 7 squads, total military organization. And his intelligence squad consisted of 500 people who were all retired intelligence personnel from RAW and Intelligence Bureau. So that was Kanshi Ram. He built this great idea of Bahujan Samaj Party. Unfortunately, that seems to have now been driven into the ground or destroyed by his chosen successor. That's Mayawati. Kanshi Ram unfortunately passed away after a long illness, and you will see this screenshot from a walk the talk that we had recorded with Mayawati in her home, where she was nursing Kanshi Ram, who was now in partial coma after a stroke. And finally, the book, The Commissioner for Lost Causes, that is Arun Shoury's editorial memoir, if I may put it like that. This is a wonderful book. I've started reading it already and I intend to finish it later tonight. It will keep me up for longer than I usually do. Arun, as an editor, in many ways revolutionized Indian journalism. And the most important contribution he made, as I see it, is that he empowered and he trusted young reporters. At the age of 23 years and 4 months, 23 years and 4 months, I was sent to the Northeast. So I was one of the many. So he similarly trusted so many other young reporters against the wishes of other established Dhakar old editors who laughed at people like us. But he's the one who made us into what we are today. Frankly, if he had not sent me to the Northeast at that point, at that age, this was 1981, January of 1981, I don't know what the trajectory and direction of my journalistic career would have been. But all of us in any profession, also in journalism, pay our dues doing one thing. So I paid my dues covering the Northeast between 1981 and 83. And that is something for which I am eternally grateful to Arun for. So please pick up a copy of the book and read it. On the cover, you see a picture of Arun and his wife Anita. You see the big smiles on their faces. And why should there not be smile on their faces? They are walking back from Rashtrapati Bhavan after Arun was given his Padma Bhushan award.